front of the court show cause hearing regarding child support. And before we get started, I have to advise you that you have the right to request a court-appointed attorney. If you make that request, we will postpone today's hearing to give you time to talk with a lawyer. And Mr. Chandler, are you requesting a court-appointed attorney today?
No, I'm not.
Okay. Ms. Mullen, please call the case.
Thank you. This is the matter of Ashley Parks versus, is it Jacarius Chandler? Parties in the case have a first order modifying order for custody, support, and parenting time signed October 11th, 2022, which orders Mr. Chandler to contribute child support and medical support for one child in the amount of $356 per month. And that charge took effect November 2022, which was a increase from a prior charge of $306 per month. There's been prior enforcement on the case. A hearing earlier in the year was dismissed due to a productive income withholding. The current balance owed on the account is $8,127.98, of which $7,600.74 is owed to Ms. Parks. And there are state arrears owed in medical support, $380.24, along with some fees. Payments on the account, more recently, in February of this year, $62.34 was applied to the account through income withholding. In March, current plus arrearage is posted to the account, which also included lump sum offsets, $1,553 and $124.94. The last payment on the account through withholding totaled $296.02.
Okay, thank you. The lump sum, what was the source of the lump sum?
I have no idea. I'm assuming it was taxes. Y'all guys have taken all my taxes for the last 2 years, totaling $12,000. So why that total is $8,000, I'm not sure. But there's got to be at least still $5,000 still missing because I haven't received taxes from last year. I have the paperwork saying that y'all took it for taxes.
It was an offset of taxes. Yeah, correct.
You said that was what, $1,000 or something like that?
The federal offset was $1,553. The state offset was $124.94.
See, there should be more then, because when I filed taxes last year, I was getting back close to $6,000. So there's still like $4,000 missing somewhere.
This was just this past year. So for the past 12 months.
That's what I'm talking about. I should have got back $12,000 last year, But okay, never mind.
Mr. Chandler, are you currently employed?
I have not been employed since the end of August. I worked in the cell phone tower industry, and with the war going on overseas, that put everything on hold as far as that industry goes.
And what kind of work? Well, who were you working for in August?
Michigan Towers.
And how long had you been with Michigan Towers?
4 weeks.
4 weeks. And then prior to Michigan Towers, were you without work for a period of time?
Where was I? I was with All Tech Wireless at one point and North Coast Cleaning LLC from like May to August.
North Coast Cleaning?
Yeah.
Okay. And what happened with the North Coast Cleaning job?
It was for Airbnb service that basically went out of business. It's not me. It's the economy.
And do you have any health issues?
Yeah, I got some stuff going on.
Do you have any health issues that are preventing you from being able to work?
Probably. I'm seeing my doctor about all that stuff now.
And what are the health issues that are preventing you from being able to work?
I have BPD. I have sleep apnea. I have severe depression. I have a lot of mental illnesses, a few.
All right. And are you
I'm still looking for work actively.
Did I hear you say that you're seeing a doctor currently?
Yeah, I'll see a therapist and a regular doctor. I see both of them pretty regularly. Okay. I just found out I have borderline personality disorder, so I'm addressing that now.
So, I mean, since you've indicated that you're having some health issues that are causing you to not be able to work, what we're going to do is send you some physician's disability forms.
Okay.
You'll get those forms, and please give those. Actually, I'm ordering you to give those to your healthcare providers,
Okay.
whoever they are, and then they'll fill those forms out and send them back to the front of the court. And I'm going to adjourn this hearing to give you time to do that. And then when we come back, we'll need to have those forms returned by then. We'll take a look at them and go from there.
Okay.
So it looks like
I do
we've
need to
got two
update my
cases
address with
for
you guys.
We'll take the case with Ms. James first, and Ms. Mullen, you may proceed.
Thank you. This is a matter of Victoria Lyons, now known as James versus Ryan Hewling. Parties in this case have a second order modifying order for custody, support, and parenting time signed October 8th, 2009, which orders Mr. Hewling to contribute a stipulated amount of child support and medical support for one child in the amount of $187 per month. The balance on the account currently owed is $1,922.78, of which $1,680.98 is owed to Miss James. There are fees and costs, and then there is a small state arrearage in medical support of $78.80. There's been prior enforcement on the case, and as well, Mr. Hewling just recently reported, I believe, new employment and payments on the account. In the past year, in January of this year, we received $861.92. That was payment through income withholding as well as by Mr. Hewling. We received an offset of $883.23 in February of this year. And then the last payment, $298.02 posted in March of this year through income withholding.
Okay. So, Mr. Hewling, is that correct? Are you currently employed?
Yes. Yeah. I just started a new job on the 26th or 27th, I believe. Due to the issue, my previous employer was taking money out of my check, not sending it in. That's why there was the big payments, because I had a show cause hearing before for this. So I ended up leaving him and kind of going out on my own. I'm in the construction business now, so doing my own work and side stuff like that hasn't really been working out for me. So that's why I just got a payroll job so I can get back on track with all this.
One moment, please. Okay, so when did you leave your previous employer?
I want to say around that March or April time.
Okay. And what is the name of your new employer?
RCI. Richter Construction Incorporation, I think.
Okay. And what do you have a particular specialty, in your field?
Not really. This is the job I'm doing now is commercial work.
And commercial, what is it electrician, flooring?
Oh no, it's carpentry.
So okay. Is this a full-time job?
Yes, sir.
Okay. And we don't have an income withholding order out yet, is that correct, Ms. Mullen?
We do, Your Honor. It was sent out on November 28th.
Okay, so it just got sent out.
Yeah, after my my final interview and I got the job, I went down. I tried to get the paperwork just to give to my work, but they wouldn't give it to me. They said they had to mail it out. So
okay. And so why didn't you make any payments, during the time, between March and November when you were trying to get your own side work business going?
Between my mortgage and bills and the 3 kids I have at home, it was kind of hard. I didn't really make enough.
And can you tell me about the status of your bills? I mean, were you behind on your bills at any point?
Yeah, my mortgage I was.
Okay. And is that why you decided to obtain this payroll job?
Yeah, absolutely. That, and it comes with benefits and working on my own. I got to cover all that at my own.
Are you in a position to make any kind of payment today, Mr. Hewling?
Yeah.
Right. Are you working today?
Yeah, I'm at work right now, but they let me step away.
Okay, so in order to make a payment, you'd have to come down to the front of the court building. But I would encourage you to do that as soon as possible. Ms. James, is there anything that you wanted to say today about how the lack of support has affected your household?
Thankfully, I've been able to put myself in a position where the lack of support did not immediately or short or long term impact us.
The statute that I'm required to apply today is MCL 552.633. Under subsection 3 of that statute, in the absence of proof to the contrary introduced by the payer, the court shall presume that the payer has currently available resources equal to 1 month of payments under the support order. This is a case where Mr. Hewling indicated that he fell behind on his mortgage because when he went out on his own in March, it just didn't work out for him. He had a good faith reason to leave his previous employer because they weren't handling the withholding correctly. And it appears based on his offer of proof that he had a shortfall in funding, which prevented him from having, 1 month of support payments. And otherwise, the court finds that Mr. Hewling has shown good cause to avoid a finding of contempt today. An order of income withholding is out. It will be producing soon. Mr. Hewling, you will be expected to pay child support as ordered moving forward, but the order to show cause today is dismissed.
This is the matter of Alicia Shenaniquet, now known as Emery versus Ryan Hewling. Parties in this case have a first order modifying order for custody support and parenting time signed November 16th, 2012, which orders Mr. Hewling to contribute child support, health insurance premiums, and medical support for one child in the amount of $390 per month. A balance on the account in this case owed is $3,811.27. Of which $3,648.27 is owed to Miss Emery. And then there are fees and costs. Excuse me, payments on the account in this case in January of this year, a total of $1,924.37 was applied. In February, an offset of $1,758.77 posted. And then a final payment in March of this year totaled $641.73.
So do we have an income withholding order, out to the same employer in this case, Ms. Mullen?
We do, Your Honor.
In that case, I'm going to dismiss this order to show cause for the same reasons stated in the prior case. Thank you.
Thank you.
Okay, thank you, Mr.
Thank you, Your Honor.
Yep, good day.
Can I ask the question real fast?
Yes.
Can I come down and readjust it to where I can pay a little of that extra off every payment? Get a new order to where, you know what I mean? Maybe throw an extra 25 or 50 a week towards each one.
So I'm only authorized to issue that kind of order after finding you in contempt of court. So at this point, because since I've not done that, I do encourage you to do that on your own, and any extra will be applied to the arrearage.
Okay, awesome.
Okay,
that's all I had.
Okay,
thank you. Appreciate it.
Thank you.
So before we get started, I have to advise you that you have the right to request a court-appointed attorney. If you make that request, we will postpone today's hearing to give you time to talk with a lawyer. And Ms. Kevwich, are you requesting a court-appointed attorney today?
Not at this time.
Okay. Ms. Mullen, please call the case.
Thank you. This is a matter of Sierra Kevwich versus Jason Schultz. This is an arrears only case as of October 2023. The remaining minor child, I believe, turned 18 and was in a guardianship. The balance on the account remaining owed by Ms. Kevwich is $5,646.29, of which $5,513.29 is owed remaining to Elisa Schultz, the former third-party guardian, who also in September of this year did waive $2,000 owed to her by Ms. Kevwich. And then there are fees on the account. There's been prior enforcement of the case as far as payments in the past year. There was one in December of 2022. $50 was applied to the account.
Okay, thank you. Ms. Kevwich, are you currently employed?
I'm still looking for daycare. I'm 161 on Angel Care's list. I've offered my son's girlfriend money to babysit. She ended up being pregnant and could not do it. I offered my boyfriend's daughter money to babysit, and she's 14. So I guess hanging out with her friends was kind of more important. So
Okay.
I currently have my 3-year-old signed up for Head Start, but I'm waiting for a spot, which, I mean, if she gets into the one that's all year round, that eliminates daycare for her, but I still have my 1.5-year-old.
All right. So, at this point, do you have what kind of regular monthly bills do you have right now?
I have my rent, my electric, my phone. I have a storage unit and car insurance. Did I say my phone?
Yes.
Okay.
And do you receive any kind of assistance on any of those bills?
I have food stamps. And then my son gets SSI. And Jason just started paying me child support, and then it stopped. It's not a lack of me trying. I'm signing up for daycares. There's just, after COVID, there's barely any daycares and they're full. It's about waiting for a spot.
All right. Okay. Was there anything else you wanted to say today?
No, I just made an $80 payment this morning, and they did take my taxes.
Okay.
I'm not sure if it was last year or the year before, but they did take all my taxes, and then I'll have taxes this year, which they'll take too.
All right. In this case, the court is satisfied based on the offers of proof that Ms. Kevwich does not have available resources equal to 1 month of payments under the support order. She's not working. Furthermore, the court finds that Ms. Kevwich has exercised due diligence to attempt to find daycare for her very young children that would enable her to be able to work. But despite her efforts, she's yet to be able to find daycare, and that's not easy to do. It's certainly she's made reasonable efforts. So the court finds, based on the foregoing, that she's shown good cause to avoid a finding of contempt, and also she's recently made a payment. So thank you. And the order to show cause will be dismissed.
6556 DP.
Right,
This is a matter last adjourned from September 14th to the day's date and time. Mr. Bach ordered to appear. Continuation of a first show cause hearing. And the parties have an order for custody, support, and parenting time signed September 9th, 2022, which orders Mr. Bach to contribute child support and medical support for one child in the amount of $292 per month, effective February 2022. The balance on the account, it was at prepping hearing this week, $1,738, but it appears Mr. Bach made a payment this month, reducing that balance to $938. Prior to this month, he made $1,000 payment in August, a $700 payment in June, and then he paid a total of $2,650 in May of this year.
Okay, so I'm very sorry, Ms. Mullen.
That's okay.
How much did he pay this in December?
Just paid $800 on the account.
Okay, 800 in December, and then before that we had a payment in August. Is that right?
Correct. In August, he paid $1,000. In June, $700. In May, he paid $2,650.
Was that voluntary?
Yeah, on his own, yes, no offset.
Okay, so Mr. Bach, can you explain, why sometimes you don't pay and then other times you pay these large amounts?
It's basically just the availability of the income I had at the time. With work being the way it has been.
Okay. And what do you do for work?
I'm a chef.
Okay. And are you full-time?
Yes.
Okay. is it kind of like a self-employed type of work, or do you have an employer?
Yes, I have an employer.
Okay, and who is your employer?
Harrington's by the Bay.
Okay, do we have an income withholding order out to there?
We don't, I don't think we were aware of that.
Okay, how long have you been with Harrington's?
I've probably been there for about a little over a year now.
Okay. So how is everything going for you financially right now?
It's tight, but it's doable.
Okay.
If we were to set up some sort of, like automatic payment plan, that it would be doable to where I wouldn't be missing payments.
Okay. That's what we'll do. We'll send an order of income withholding out to Harrington's, and once that gets set up, they'll deduct a certain amount periodically from your pay, and
That
that'll
would be
kind of take care of that. Otherwise, based on the $800 payment this month, and the fact that an order of income withholding is going out, the court finds good cause to avoid a finding of contempt. The order to show cause is dismissed. Thank you.
Thank you. This is an
Thank you,
adjourned
Your Honor.
matter from September 14th to today's date and time. Mr. Dybert was to provide verification of manifest hardship within 14 days, which I could not locate in the file. There's been prior enforcement, but that was back in 2015. The parties have an order for custody, support, and parenting time signed March 25th, 2011, which orders Mr. Dybert to contribute child support and medical support for one child in the amount of $299 per month. The balance on the account currently owed is $1,128.67, of which $897 is owed to Ms. Trafford in child support and medical support. There are fees, and then there's a 67-cent recovery balance that is owed to the MISDU. Payments on the account since the September show cause, there was one involuntary intercept of $1,383 in October. Prior to that, May of this year, current plus arrearage is posted through income withholding and offset as well.
Okay. And did the order indicate what kind of verification was being required, Ms. Mullen?
It just says that he reported significant manifest hardship, ordered to provide verification of the same to front of the court within 14 days.
And Mr. Dybert, how come you didn't get any kind of paperwork showing your situation to the front of the court?
I guess I did not remember to do that.
Okay, so that was an order, and I assume are you residing at the address that the front of the court has on file for you? Are
Yes.
you mail? Okay, all right then. Was there anything that you wanted to say today regarding your financial situation?
I'm just waiting, trying to do disability. I went on October 30th for an independent medical exam, so I'm just kind of waiting on this process.
Okay, and do you see a physician or other healthcare provider on a regular basis?
I have different specialists kind of. Next Monday, I have some procedures.
Is there a particular specialist that you see most often?
I was seeing a Dr. Herringa in Cadillac. He was kind of not able to help me out. He actually referred me to a doctor up in Traverse City. So that's where I'm going to, I went there last week, and I have a procedure scheduled for this Monday.
I see. So this will be your second appointment with that healthcare provider?
Yes.
Okay, so here's what we're going to do is we are going to send you, and I have a question. Is that the only healthcare provider that you're currently scheduled to see or that you're seeing?
As in the future, as now, yes.
Okay,
I mean, I have my normal doctor, but
we'll send you a couple physicians disability forms. It's the name of the form. You'll get a couple of them, and you're ordered to give one to your regular doctor.
Okay.
And you're ordered to give another one to this specialist that you're going to be seeing on Monday.
Okay.
And even if you don't get it in time for your appointment on Monday, you're ordered to take it up to that doctor,
I'll have
when you get it.
Okay.
And then those healthcare providers are going to fill these forms out, explaining from their perspective what the health situation is. They'll send them to the front of the court. once we get them, we're going to reconvene this hearing, take a look at them, and figure out where to go from there.
Okay.
Ms. Trafford, because of the health issue that's been indicated, I am going to adjourn this one additional time. Mr. Dybert, I am cautioning you that if you continue not to provide the paperwork that's being requested, I mean, we will have to hold you in contempt. So,
Okay.
the second time. Otherwise, Ms. Trafford, at the next hearing, you'll have an opportunity to speak and explain how the lack of support is affecting your household. But for the reasons stated, I'm adjourning this hearing to give Mr. Dybert time to get these forms and give them to his doctors. That will conclude our hearing.
This is an adjourned matter from November 2nd to today's date and time. Parties have a first order modifying judgment of divorce signed March 29th, 2019, which orders Mr. Dine to contribute child support and medical support for one child in the amount of $78 per month. There was previous enforcement on the case, but hearings had been previously dismissed. Current balance owed $527.86, of which $282.23 is owed to Ms. Herman in child support. The state is owed $182.63, and then there are fees. Recent payments on the account, we had, it looks like Mr. Dine, I believe I was reported, made a payment a day or so ago for $100. Prior to that, he paid $300 in August of this year and $724.20 from an offset in April of this year was applied to the account.
Okay, and just to be clear, Ms. Mullen, what's the total amount owed at this point?
Right now, the current balance is $527.86. I do show receipt of the $100 payment made this week. It's on its way to Lansing, and so therefore hasn't adjusted the account yet.
Okay. All right. So Mr. Dine, are you currently employed?
I currently run my own business, and I do believe that there is a payment missing on that. After the last court hearing that was missed on my behalf, previous to that one, following that date, a payment was made to both of my cases, and I do not believe I heard that one read off.
All right. And so when are you asserting that you made that payment? If you could give me like a month.
I would give, I'm trying to remember the month that case was in. I believe it was, we're in, I would say late September, early October. And I believe that payment was definitely made in October. In person, cash, at front of the court.
Okay. And how much did you pay in cash at the front of the court in October?
From what I can recall, I believe it was $100 to $150 to each case.
So you made a total payment of $300?
Yes, divided among the two cases that I have.
Okay.
This case, I would say $100 to $150 was allocated.
Okay. And you're saying that that the front of the court has misplaced that payment?
I don't know what exactly happened, but I know I made a way more recent payment in August, and it is the last payment that I heard read off. Is that correct? Was August?
Mm-hmm.
Correct. That's correct. That's the last one read off.
Yeah, I 100,000,000% have made an additional payment other than that August one. I will have to look into the specifics to my records, the amount and date that was made, but I do know another one was made.
Okay. So what is the business that you run?
It is a water treatment business. I just started that less than 2 years ago, about a year and a half now.
Okay. And is it a DBA or an LLC?
It is an LLC with a co-owner.
Okay. And do you, well, I guess, what exactly do you have to do for the business, I guess is my question.
Just like at Culligan or Douglas Water Treatment in our local area, I go into homes, do water testing, and mitigate any water issues that they might have, water quality issues that the customer might have.
Okay. And I mean, do you have any other side work or side source of income besides the business?
No, that is my full time.
Okay. What's your housing situation?
Currently, I reside with my wife and one child full time and 3 children. Every other week, we rent.
Okay. And as far as your regular monthly bills, I mean, do you have a rent payment or a mortgage payment?
Between rental, vehicles, and everything else, I know we're just below $4,000 a month.
Okay. And are you current on those bills at this time?
Currently, my knowledge, most of them, if not all of them, yes, with the exception of the child support.
Okay. All right. Was there anything else that you wanted to say today?
Nope. Other than I apologize for missing the last hearing. It was a human error on my part. I had it in my calendar, and I guess I did not set the reminder text to come to me, and I realized a couple days afterwards.
Okay. Just, I guess, maybe a couple more questions from the court. As far as I understand, you're indicating you made the payment in October, but how come there was no payment in November?
No payment in November. So really, it's come down to available funds that I have at that time. I'm really kind of just dishing out as much as I can when I can. Don't really have any. Go ahead.
Was that also, I mean, I'm looking at September was a 0, July 0, June 0, May 0. Is it kind of the same situation? Okay.
Yep.
All right.
Exactly.
Ms. Herman, was there anything that you wanted to say today?
Nope.
Okay. So the statute that the court has to apply today is MCL 552.633. That statute provides in subsection 3 that in the absence of proof to the contrary introduced by the payer, the court shall presume that the payer has currently available resources equal to 1 month of payments under the support order. The support order in this case requires Mr. Dine to pay $78 a month. The court doesn't find that he's provided an offer of proof to suggest he's not capable of paying $78 a month. He's paid more than that on several occasions. Even taking into account his assertion that he made a payment in October that from which about 150 would have been credited to this case, and taking into account the $100 payment that he's made this month, that would still leave a rearage of approximately $275. The statute provides in subsection 1 that the court may find a payer in contempt if the court finds that the payer is in arrears, which is the case here, and one or more of the following apply. And section 1A states that if the court is satisfied that the payer has the capacity to pay out of currently available resources, all or some portion of the amount due under the support order. This is a case where payer indicated that he's current on most, if not all, of his bills. He runs his own business. He's able to cover household expenses of $4,000 a month, except for, curiously enough, the child support obligation. The court finds on this record that the payer in this case does have the capacity to pay out of currently available resources, essentially more than the amounts paid in November, September, July, June, or May. Those were all zeros, and the court finds that this payer has the capacity to pay some or all of the current arrearage, which is only $275. Therefore, Mr. Dine, you are being warned today that you will need to be paying your child support as ordered. If you show up in front of this court again, you will be held in contempt. Otherwise, the show cause is dismissed.
So my wife just messaged me here. She has the receipt. She's gonna have to dig that up in our records. But it is believed that $250 to $300 was paid to Madison's case in March.
please submit that paperwork to the friend of the court so they can look at it. And more importantly, or equally as importantly, so this court can look at it if you're ever in front of this court again. And I hope that you're not. That will conclude our case.
Thank you.
Oh, Mr. Dine, we've got a second one for you. Go ahead, Ms. Mullen. You can call the case.
Yes. In this case, parties have a consent judgment of support, final judgment signed June 10th, 2019, which orders Mr. Dine to contribute child support and medical support for one child in the amount of $44 per month. This is a continuation of a original show cause hearing. Again, made a payment this week of $100, which is pending being applied to the account. So the current balance owed in this case is $319.18, of which Ms. Whitcop is owed $104 in child support. The state is owed $152.18 in medical support. And then there are fees. Payments that have receded to this account in the past year were April of this year, an involuntary payment of $383.80. In August of this year, $200.
All right. Ms. Whitcop, was there anything that you wanted to say today?
No, not that I can think of.
Okay, so Mr. Dine, again, it's the same situation. If there's paperwork that you feel, shows there was a mispayment, please submit that paperwork to the front of the court. At this time, you are warned that you need to make your court-ordered payment monthly. The show cause is dismissed because essentially there is some ambiguity. And there was also apparently a payment made this in at least one of the other cases this month. I don't know why it wasn't applied to this case. But all in all, Mr. Dine, it's the court stresses that if you're back in front of this court again, you've got the capacity. This court's already made that finding. You're more likely than not to be held in contempt. That'll conclude our hearing. Talk with the lawyer. And Mr. Lebrecht, are you requesting a court-appointed attorney today?
Can I make this decision after we proceed a little bit so I can make that determination if I think I'm going to need one?
Well, I guess so, but if you do it after I hold you in contempt, it'll be too late. So you're kind of taking the risk. You're assuming the risk at this point if you're not just going to ask for the court-appointed attorney. Do you understand that?
I guess not. Why would I don't understand why I'd be held in contempt, I guess. I don't know exactly everything that's going on. Maybe I do need to get an attorney.
You would be held in contempt if the court finds that you have failed to make child support payments without a good excuse. Do you want a court-appointed attorney today, or should we just get started with the hearing?
Let's go ahead and get started.
Okay. And we've lost the recipient, so I'm not sure what happened with that. But I guess if she shows up in the waiting room, we'll bring her in as soon as possible. Ms. Mullen, if you would, please call the case.
Thank you. This is a matter of Amanda Burrows versus Joseph Lebrecht. Mr. Lebrecht is here today after failing to appear at a hearing which was held November 2nd, 2023. The bench warrant was authorized for him November 3rd. The bond was set at $6,909. He posted a reduced bond of $100, and the warrant was recalled, order to appear. Parties have a fourth order modifying order for custody, support, and parenting time in this case, signed March 27th, 2023, which orders Mr. Lebrecht to contribute child support and medical support for one remaining child in the amount of $338 per month. The balance on the account currently owed is $7,484.57, of which $3,881.78 is owed to Ms. Burrows. There are fees and costs, as well as some state debt owed $2,154.79, which is medical support along with birth and delivery. Mr. Lebrecht did respond to a request to provide his ability to pay information for the hearing today, which I can pull up for the court if they wish to review. And as far as payments on the account in the past year, the only payment made was the $100 reduced bond.
Okay. So Mr. Lebrecht, in the form that you submitted, you indicated that you're a flooring installer. Is that correct?
That is correct, Your Honor.
Okay. And are you self-employed or do you have an employer?
I'm self-employed.
And do you have a general contractor that you typically get jobs from?
I used to, yes.
the tail end of lockdown from COVID, I lost my house and job and everything around that time frame. And I haven't really worked since then. I had to move in with my mom in Manton, and not having a driver's license or vehicle, or a helper to even drive me to jobs or anybody I could count on to show up to jobs. I didn't want to burn bridges with contractors, being able to not show up, day to day, or not knowing if I'm going to be able to show up. So I haven't really worked since then. I am starting to work again now. I'm actually on a job. This is the first week I've actually been back to work in a couple years.
You haven't worked since 2021?
Not really. I've had some odd jobs here and there. I've helped some buddies out fixing cars here and there. Made a little bit of money, but I've basically been living with my mom, trying to get back on my feet.
All right.
I've done things for her around the house, or things that odds and ends that I can do to make a little bit of money here and there, but that's been about it. Okay. I'm on assistance myself.
Are you? What assistance are you receiving?
Well, food. I receive food benefits.
Okay. Okay. And are you having any health issues?
No.
Okay. And do you have a driver's license?
I do not. That's been a major hiccup. I do have an attorney retained. I'm going through the steps and motions to get that. My mom actually helped me with the $2,000 to get an attorney, that the cost of him. There's other costs obviously that are going to be needed, and I'm just trying to get back to work. To get going, I'm trying to get back on my feet with things. So I'm in the right direction. Just going to take time.
How long have you been without a driver's license for?
A very long time, Your Honor. 15 years.
Okay. Does your mother, is she employed?
She's retired.
She's retired. Okay.
Yeah.
And
she's on a fixed income.
Does she have a driver's license?
She does.
Okay. Does she have a vehicle?
Yes.
Okay.
And she's helped me out a lot on transportation.
Sounds like it. But prior to COVID, did you have a particular general contractor that you did work for?
I did. It was in Elk Rapids.
Okay.
Harbor Flooring.
Okay.
I did a lot of work with them. I was with him for about 4 years.
Anything else you wanted to say today?
My one thing that I'm confused on, I don't remember the exact year.
Yeah.
Amanda and I had written up an agreement to be out of the courts for child support. Yeah. And we both signed the paper and handed it in. And now it was just reinstated because I think my daughter because she was put on Medicaid, I think is kind of what reinstated everything.
So
I'm not sure.
That automatically does happen when Medicaid gets involved.
Yeah, I think that's what happened, and that's kind of why we're in this. I think that's, to my understanding, is why we're in this situation.
All right, Ms. Burrows, can you hear me?
Yes, I can.
So, Ms. Burrows, is this a case where did you agree to write off a certain amount of the arrearage, or is that not happening here?
Maybe not that I recall. Maybe a long time ago, like years ago when they were little, I might have done something like that.
Okay. And
so agreed that he would help me out with my children, but he doesn't. So never has.
Okay. Was there anything else that you wanted to say today, Ms. Burrows?
No.
Okay. All right, then. The statute the court has to apply today is MCL 552.633. Under section 1 of that statute, the court may find a payer in contempt if the court finds that the payer is in arrears, which is the case here. And if the court is satisfied that by the exercise of diligence, the payer could have the capacity to pay all or at least some portion of the amount due under the support order, and that the payer fails or refuses to do so. Here, the court finds that there has at the very least been a failure, if not a refusal. Payer, Mr. Lebrecht, he's been without a license for 15 years. So, I mean, that must not have been an issue when he was working for Harbor Flooring in Elk Rapids prior to COVID. He's an experienced contractor, but he's not exercising that skill, and he was able to do so without a license prior to COVID. His mother is available to provide transportation to help him, I would assume, go to various jobs, or at least apply to jobs and then go to them. So the license in this court's eyes isn't really a good cause to avoid a finding of contempt. And there's really no excuse for him not really having worked since 2021. There's no health issues. The court finds on this record that it must hold Mr. Lebrecht in contempt. Mr. Lebrecht, you will be placed on probation for a period of 2 years. During that 2-year period, you will have to make payments according to the following payment plan. You'll have to pay your court-ordered child support timely each month, plus an additional $87 each month towards the arrearage. If you do not make payments according to that plan, a bench warrant will be issued for your arrest. The amount of the bond will be set at $1,000, which you will have to pay or serve 15 days in jail. This is a deferred jail sentence only. If you make that request, we will postpone today's hearing to give you time to talk with a lawyer. And Ms. Nambuki, are you requesting a court-appointed attorney today?
Why wasn't I given an attorney at the previous?
I don't know. I can't. Was I presiding over that hearing?
I'm not sure, but is it standard that they would offer one? Because this is the first time that I'm being offered one. I would have taken that option 3 so-called hearings ago.
Well, Ms. Nambuki, I don't know what happened at this other hearing, but this is what I do for the hearings. So I guess we'll go ahead and appoint you an attorney today.
I guess I don't, since it's so, I'm trying to get it taken care of and rectified now. So I think having an attorney this late into it wouldn't necessarily be beneficial.
Okay, very well done. Ms. Mullen, please call the case.
Thank you. This is a matter of Nicholas Otto versus Danielle Nambuki. This hearing is adjourned last from September 14th to today's date and time. Ms. Nambuki indicated manifest hardship, and she was to provide proof of such within 14 days. We did receive some medical documentation for the course review, and also she was to contact front of the court regarding family support court, which I believe looks like there was attempts made back in October.
No, there wasn't an attempt. There wasn't an attempt. I actually did make contact with Mr. Green or whatever his name is. There was no attempt. I made contact with him. Yes, I made contact with him. Did he note that he spoke with me and what we discussed?
No, it was just an indication there was a message left, ma'am. So I don't know what.
No, we spoke on multiple occasions. So is that a way of like sabotaging this or something, saying that I only left a message when I spoke with him on multiple occasions?
Ms. Nambuki, if you believe that something, unethical or wrong is happening, you have a way to file a complaint with the friend of the court. You can go on the friend of the court website to access those documents. But at this point, this is really not the place to address those types of complaints. Do you understand?
Yeah, well, if that's not a fact, if you're telling me that I only made contact and I know, and the man knows that I've made more than contact over a voicemail, then that's wrong. And I'm going to let you know that that's wrong, because you said that this is recorded and you know what I'm saying? So that's not a fact. So I'm definitely going to call that out and address that that's not the fact, which is what I did. I let you know that that's not a fact. I spoke with the man multiple occasions.
I guess, Ms. Nambuki, isn't it kind of like how can you prove that you're right, and how can Ms. Mullen prove that she's right? Do you see my dilemma here? How can either one of you prove at this point that you're right? Do you see what I'm saying? I mean, right? I mean, it's kind of.
No. Who am I and what do I know?
I'm sorry,
right.
What?
So who am I and what do I know? So you're right. Go ahead. You can finish whatever you were saying.
Okay, so I think that Ms. Mullen was just describing the details of the case, so you may continue.
I may continue, Your Honor?
Sure.
Oh, okay, I'm sorry. Thank you. So yes, there was noted contact or messages left between Ms. Nambuki and Mr. Greenman. The current balance owed on this account, and I don't see that there's been a joining of family support court, but that's the only information I know, is $2,684.62, of which $2,432.56 is owed in child support to Mr. Otto. Medical support owed to the state is currently $192.67, and then there are fees. There was prior enforcement back in 2017. And as far as payments on the account in the past year, in July of this year, $100 was paid by Ms. Nambuki. And September of this year, $140 was paid on the account.
Okay, thank you. One moment. Okay, so Ms. Nambuki, do you remember what documents you submitted to the friend of the court that were described by Ms. Mullen?
The only documents that I was asked to give to the court was documents regarding my medical history as far as having the surgery within the past few months. I had 2 surgeries on my hand. I was told to show you guys that, which is what I did.
Okay.
Right?
One moment, I will look at those documents. Thank you. I've had a chance to look at those documents. Ms. Nambuki, I guess, what is the status of your I guess, post-operative situation with your hand surgery at this time?
I'm done with surgery. So I'm all done with surgeries. I'm healed. I currently did find employment. One of them starts in February. One of them I start on Monday. So.
And what employment do you start on Monday?
At Riverview Terrace in Riverview, Michigan.
Okay. And will that be a full-time or part-time job?
Full-time.
Okay. And what will you do for Riverview Terrace?
Work.
Okay. And do you know what kind of work it will be?
I'm not sure. I'm just going to be working. I'm going to do whatever they tell me to do so I can get you guys your money. Is there anything else? What else do we need to talk about?
And then I guess we'll send see if we can send an order of income withholding out to Riverview Terrace. And then the job that starts in February, what job will that be?
It's another job. It won't start till February, so I'll let you know then. If it doesn't start till February, there's no point in really discussing or addressing that now. So we can talk about the job that I am starting on Monday, because that will be effective as of Monday, not February.
Right. And Ms. Nambuki, I guess, as far as your current situation financially, what is your housing situation?
I have a home. I have a home. I have a place to live. Why does that have anything to do with me paying child support?
Smith versus Smith 155 Mishap 752 requires the court to examine the payer's employment history, education and skills, work opportunities, diligence in seeking employment, defendant's personal history, including present means of support, assets, health and physical ability to obtain employment, and availability for work. So I'm asking these questions because I'm required to by the law. As far as any kind of outstanding bills, I mean, are you current on your bills or other situations?
No, I had to, in the past year and a half, I've had to bury both of my parents by myself financially. So no, I'm not. I have credit card debt. I have debt. What does this have to do? I don't understand. I'm going to pay the child support. Okay. I start my job on Monday. It's crazy how you guys are so pressed and so intent on making me pay money for a child that my baby's father does not give me. I'm entitled to rights as a parent, and you guys never address that. I've sent letters during the pandemic to address it. I've never received any information back from your guys on your end. But you guys are calling me asking me for money. I've been calling and asking for my child. You guys allow this man to dictate and determine when he's going to allow me to be a parent. You guys allow him to do that. And now it's been taken too far. This has been gone all over years of you guys allowing him to do it. And you think that it's okay. He thinks that it's okay. And now it's to the point of no return. I'm going to pay the child support. Is there anything else that I can help you with? I have employment. I will send you guys the employment information on Monday as soon as I get it and get the paperwork from them. Is there anything else I can do for you today? Because I'm extremely frustrated from not getting assistance from your guys on your end at all, but you guys are constantly assisting him. Okay, so what else can I do for you today?
Ms. Nambuki, I'm very sorry to hear, that you didn't get a response to your, I assume you filed parenting time complaints.
Right, multiple times. I have not seen my son in 3 years. My son has a room at my house. Wherever I live, my child has a room.
So, I would encourage
So
you.
you guys do your job. I'm convinced that this is biased. I'm convinced that it's racist. I'm convinced you guys, because it's crazy. I'm black and I don't get any assistance from you guys, and he's white and he gets all the assistance. Okay. So that's where I'm having the issue and the frustration, because over years I have not gotten any assistance from you guys at all. But you guys are constantly calling me about child support. He wants him so bad, and he wants to keep him from me so bad. So why do I have to dish out money if this is what he's deciding? This is not me saying I don't want to take care of him. I don't want to have physical custody. I don't want him here with me. This is his doing. And you guys are forcing me to give money after he's saying that he doesn't want me to have him. So what am I paying for? So at this point, what else is there that I can do for you? I want to make this very quick because I have other stuff that I have going on today. So what else can I do for you? Is there anything else I can help you with? I will send you all of the information regarding the job so you guys can withdraw or take or whatever the case may be. What else can I help you with? Because I am frustrated. I'm at my wit's end. This is tiring. This is draining. So,
Ms. Nambuki,
if there's nothing else I can help you with, I would like to end the call.
I just want to let you know that, you've shown sufficient good cause by everything you've indicated today with the health issues. You've made a diligent attempt to get the job that you're going to be starting. And you've indicated that you're going to provide information regarding that job. And you've shown that you've had, certainly a lot of debt because of the tragedies that you've experienced this year. And I'm sorry for all those reasons. Of course, you're not in contempt today. And I'm very sorry, for the stress that you're under. I can tell that you're stressed. I do hope that you will at least try to file some more parenting time complaints. Please don't give up on that.
So what is the point in me keep doing it and taking the time to do what I'm supposed to do on my end to not get anything from it? What is the point in me doing that? At this point, there is no point. There's no purpose. You guys don't help me. You guys do not assist. Okay? So what's the point? Can we please just end the call at this point? There's nothing else that we need to talk about. I told you I would pay. I'm done with the call.
Ms. Nambuki and Mr. Otto, I've made my findings, so we can end the call.
Okay, thank you.
The order to show cause is dismissed. Thank you.
008613 DM. This is an adjourned matter from October 5th to today's date and time. Mr. McGraw to appear, provide employment information immediately, which I could not locate, and also make a payment of $100 within 14 days. Payment was made, but because Mr. McGraw has another charging case in the state, a portion of the money went to that case as well. Parties in this case have a fourth order modifying judgment of divorce signed December 13th, 2012, which orders Mr. McGraw to contribute child support, medical support, and health insurance premiums for one remaining child in the amount of $286 per month. The balance on the account currently owed is $2,137.56, of which $2,098.72 is owed to Ms. Brandt. There's medical support arrearages owed to the state, $17.84, and then there are fees. Payments on the account since the October adjournments was $83.14 was applied of that $100 payment made. And then he made a payment as well in November, $100, which this case again received $83.14. Okay. Prior to that, in April 2023, we had an active income withholding and the account was current at that point.
Okay. Thank you. Okay, so Mr. McGraw, are you currently employed?
Not right now. I've
Okay.
been searching.
No, what? It's okay. When were you last employed?
Back in it was the end of June, middle of June.
Okay, one moment. And what were you doing for work at that time?
I was cook.
Okay. And what restaurant or place did you cook at?
Charlie's Family Grill in Fremont.
Okay. And how long were you with Charlie's for?
Only a few weeks.
What?
About a month. About a month or so. I'm sorry.
Okay. Why did you separate from that employer?
A lot of drama, and they weren't withholding anything from me. And it was really shady.
Okay. And then prior to Charlie's, were you without work for a period of time?
No, I was working at the Brook of Newaygo up through March, I believe.
Okay, so you worked at the Brook from March until you worked at the Brook. You left the Brook in March, is that right?
Yeah, it was like the end of March, middle of March.
Okay. And why did you how long were you at the Brook for?
Year and November, October, or December, January, February, March. About a year and 5 months, 6 months.
Okay. All right. And why did you leave the Brook?
Well, I thought going back to Charlie's was going to be a good deal, but it wasn't what they said. So, yeah,
Okay.
kind of.
So you had worked at
myself up
Charlie's
there.
previously then?
Right, and it was
Okay.
the same thing, and I don't know why I went back.
Okay. Okay, so what is your housing situation?
Excuse me?
What does your housing situation look like?
I'm staying with a friend right now. Like I said, I've been searching. I've been putting apps in my resume and on Indeed. I've been putting like 3, 4, 5 a day. I've had several interviews. I've had several second interviews, and then I don't hear back from them. And I try to contact them and ask them what's going on, and I don't hear from them. So I'm like, kind of in a okay.
Okay. And then
I called yesterday because
go ahead.
I just got this. I'm sorry. I called in yesterday to the court because I just got this paperwork today or yesterday afternoon. I just had so much going on. I thought I had an interview this morning, but it's not until tomorrow morning. And then after I got off the phone with, I believe it was Mr. Hogue, I think, yesterday, then I found out my brother is clinging to life in the ICU. So I'm I've been all over the place.
I'm very sorry to hear about your brother.
Yeah, but I'm vigorously trying to get employment. And I just started, I was telling Mr. Hogue yesterday that I just started doing like deliveries for Shipt and Instacart to try to get money to pay my support and stuff. So I guess you can consider that self-employment. I'm not sure.
Okay.
So I started doing that, and I was hoping I could maybe make enough to make a payment this week, actually, before I even got this paperwork. That was my thought. I was going to send in another 100. And at the time, like I said, I didn't know that part of it went to Kent County also. I was like, I thought I was in the good. But he explained to me that part of it goes to the MISDU, and then part of it goes to Ms. Brandt up there, and then the other part goes to Kent County.
Okay. And does your friend charge you rent
No. Not until I get back on my feet.
And do you have transportation?
Yeah.
And when did you start Instacart?
Last weekend actually, Saturday.
Last weekend. Okay. And you when did you make your last child support payment?
Oh, it's just a couple weeks ago. I thought I was paying that one to Kent County.
Question: if you started Instacart last weekend, where did you get the money to pay the child support payment that you made a few weeks ago?
I borrowed it.
From whom?
A friend.
Okay. All right.
I'm kind of, that's why I've been out, like I said, I've been out applying for jobs. I've been going to interviews, doing interviews.
And who is your interview with tomorrow?
Tomorrow I got one at Sparta, Michigan, for the American Legion Eagles. It's my second interview there. I'm hoping something works out with that.
All right. So do you have a car payment or anything like that?
Yeah, and I'm behind on that right now too.
How much is your car payment?
Supposed to be $500 a month. They lowered it to $250 until I can get back on my feet.
And you're behind?
Yeah, I haven't. I called and worked out something with them. Hopefully they put a hold on it for a month, basically.
Are you behind on any other bills?
No, not that
Okay.
I know of. Just my support and my car payment.
Ms. Brandt, was there anything that you wanted to say today?
Nope.
Okay, so the statute the court has to apply today is MCL 552.633. That statute provides in subsection 3 that in the absence of proof to the contrary introduced by the payer, the court shall presume that the payer's currently available resources equal to 1 month of payments under the support order. In this case, the payer is ordered to pay, it looks like 200, and I can't read it if it's 86 or 96. I can't see very well anymore, but it's okay. But Mr. McGraw is not even able to afford his car payment due to his financial circumstances. So he has rebutted that presumption on this record. Subsection 1B pertains to the exercise of due diligence. Mr. McGraw has exercised due diligence. He indicated he's thrown in 3, 4, 5 applications a day with Indeed. He's got a job interview set up for tomorrow. He has gone ahead and gotten the Instacart job. So he's made a good faith effort to become reemployed in order to pay support. The court finds on this record that he's shown good cause to avoid a finding of contempt. The order to show cause for contempt is dismissed. Thank you.
Thank you.